This is a presentation on the Fair Chance Act presented by the Civil Rights Department's Outreach and Education Unit. One quick disclaimer before we get started. This guidance is for informational purposes only, does not establish substantive policy or rights, and does not constitute legal advice. Any information I'm sharing is based on the most recent guidance as of the date of this recording, but it is your responsibility to stay on top of any changes in the guidance and the laws. What is CRD? CRD is a California state agency whose mission is to protect the people of California from unlawful discrimination in employment, in housing and public accommodations, so like public businesses, as well as protect them from hate, violence, and human trafficking. We have many responsibilities, including investigating complaints of discrimination and other civil rights violations. We facilitate dispute resolution involving civil rights matters. We prosecute violations in civil court. We issue regulations to provide more clarity about the laws that we enforce. We collect data on the pay and the demographics of large employers' workforces, and we report that information out on our website. We do what I'm doing right now, which is we conduct outreach and trainings to let Californians know what their rights and responsibilities are under civil rights law. And finally, we work with communities and local and state public bodies to constructively manage and resolve discrimination-based conflict. We do provide accessibility services for people with disabilities, including people who want to file a complaint with our department. So if you need a reasonable accommodation, please call 800-884-1684 for a voice call, 800-700-2320 for teletypewriter, or California's relay service at 711. You can also email accommodations@civilrights.ca.gov. We also offer bilingual services and translations for people with no or limited English proficiency. Please reach out to contact.center@calcivilrights.ca.gov to arrange for services in other languages. Please note that many of our educational resources are also translated into other languages on our website. All right, so let's get started with an introduction to our topic today. First, I want to note that throughout this presentation, I will be using people first language to describe people with criminal records. Why is that? That's because language is really important in affirming people's dignity. So as a result, I avoid using terms that reduce people to just one aspect of their personal history. So like instead of using a word like convict or felon, I will use person with a conviction history or person with a felony conviction. Similarly, instead of sex offender, I will use person on the 290 registry, which is the sex offense registry. And instead of parolee or probationer, I will use people on parole or people on probation. Before we dive into the law, I want to share some statistics about the likelihood of reoffending for a formerly incarcerated person. Basically, the tendency of a person with a criminal conviction to reoffend is called recidivism. And one study found that the rate of recidivism, meaning the likelihood of reoffending, drops fairly considerably after 3 years and then even more after 5 years. This means that according to this data, people are most likely to reoffend in the first year of release from jail or prison, and the farther someone is from their time in prison or jail, the less likely it is for them to go back. Why am I sharing this? I am sharing it because some employers tend to be really concerned that if they hire someone with a conviction history, they may reoffend, maybe they'll be dangerous, but this data shows that it's really unlikely to be the case, especially if they were released from prison or jail many years prior. Now that we have placed this law into context, let's talk a little bit more about what this law is and how it works. The Fair Chance Act is a law that went into effect back in 2018. It is part of the Fair Employment and Housing Act, which is one of the main laws that the Civil Rights Department enforces. Its purpose was to reduce barriers to employment for people with conviction histories and make it easier for them to reintegrate into society. The Fair Chance Act applies to public employers as well as private employers with 5 or more employees. This includes union hiring halls, labor contractors, as well as temp agencies. One thing to note is that the Fair Chance Act applies to job applicants as well as existing employees, including those who start work before their employer runs a background check. So, for example, if a current employee was up for a promotion or otherwise undergoing a background check, like let's say someone has been working at their job for several years and then the company suddenly changes owners. If the new owner wants to run background checks on all existing employees, the Fair Chance Act's protections would still apply, even though the person is not applying for a new job. Another thing to note here is that regulations went into effect in October 2023 that clarify some aspects of the law. The regulations have been incorporated into this presentation throughout, and as appropriate, I'll be flagging them for your awareness. There are some exceptions to the Fair Chance Act, which means that some employers are not subject to the law. This includes law enforcement and criminal justice agencies like police departments, parole and probation, things like that. It also includes farm labor contractors, certain positions at healthcare facilities, or jobs working with sensitive populations like the elderly or like children. The Fair Chance Act also includes a kind of umbrella exception for any position where an employer is required by law to conduct background checks or resist employment based on criminal history. So for example, there is a law in the Public Utilities Code that requires rideshare companies like Lyft and Uber to run a background check and restrict hiring if someone has been convicted of specific crimes. As a result, rideshare companies are an exception to the Fair Chance Act. But note that if there is a law requiring an occupational licensing board to conduct criminal background checks, any job requiring that license will not automatically be exempt from the Fair Chance Act. So, for example, I am an attorney and I am licensed to practice law. When I got my law license, I got a background check done, but that doesn't mean that any job I apply to is going to be automatically exempt from the Fair Chance Act. Another note to mention briefly is that even if an employer is exempt from the Fair Chance Act, their use of criminal history may still be discriminatory and therefore potentially illegal if it has an adverse impact on a protected category like race. We are not going to dive too deep into that today, but if you are interested, there is more information in the 2023 regulations. Turning now to how the Fair Chance Act works before a conditional offer, let's get into it. An important aspect of the Fair Chance Act is that an employer cannot ask about or consider a person's conviction history or criminal record before extending a conditional offer of employment. So on the screen, I have a hiring timeline with the conditional offer designated with a big arrow. Everything before that point, meaning the job ad, the job application, and the interview, are in red to show that at those phases, an employer cannot ask about or consider someone's record. Note that this also means an employer can't ask a candidate directly, can't run a background check, and can't even do an internet search. Turning now to job applications and job advertisements. The Fair Chance Act makes it against the law for employers to make statements saying that no persons with criminal history will be considered for hire. At CRD, we actually have a program where we look on websites with job boards to see if there are any posts with this kind of illegal language. And what we've found is that tons of employers are still saying things like no felons, must have a clean record, must pass a background check, all of which is a violation of the law. At times, we're also seeing job applications that say things like, have you been convicted of a crime in the past 10 years? And to be clear, that language is also a violation of the Fair Chance Act. In fact, the Fair Chance Act is sometimes called Ban the Box or the Ban the Box law because it made it against the law for most employers to have a question like, check yes or no if you've ever been convicted of a crime. If you see these kinds of discriminatory ads or applications, you can let CRD know by visiting bit.ly/CRD-discriminatory-notices. The Fair Chance Act has protections in job interviews too. Specifically, the Fair Chance Act makes it against the law for employers to ask about or consider someone's conviction history during a job interview unless the employer has already made a conditional offer. What is a conditional offer? To get a sense of what it sounds like, it might sound something like, we think you're a great fit. You're hired pending the results of a background check, or you meet the criteria for this position. We would like to offer you the job, conditional on you passing a background check. But note that if an employer asks about a candidate's conviction history before the conditional offer, like during an interview, the employer can't then use the candidate's failure to disclose against them in hiring. For example, we have our friend Maurice. He applies for a job at a national big box store. The hiring manager says, this job requires running a background check. Is there anything you want to disclose to us before we do that? Maurice says no. When the company runs the background check, they discover that actually Maurice has a 5-year-old conviction for possession of a firearm. Maurice had mistakenly believed that this conviction was expunged, which is why he didn't say anything during the interview. The big takeaway here is that the big box store can't refuse to hire Maurice because he didn't disclose his conviction. Why is that? Because the employer should never have been asking about it at this stage of hiring to begin with. All right, turning now to off-limits information under the Fair Chance Act. There is some information that an employer can never consider, not at any point in hiring. This is true even if the person self-discloses or volunteers that information. Under the Fair Chance Act, this includes arrests that did not result in a conviction, but not an arrest that's currently pending. That actually can be considered. The difference there is if I was arrested 5 years ago, maybe the prosecutor never pressed charges and my case was dismissed. That's an old arrest that can't be considered. But if I was arrested over the weekend and I still have to go to court to get a resolution or disposition in my case, then that can be considered. In addition, any convictions that have been sealed, dismissed, expunged, or statutorily eradicated cannot be considered. And any successful completion of a diversion program, something like drug court, or certain counties have homeless court. I want to make a quick note about the Work Opportunity Tax Credit. This is a tax credit that helps employers hire people from certain targeted groups that have historically faced barriers to employment, which does include people with felony convictions. Any employer who wants to take advantage of the Work Opportunity Tax Credit certainly should, but note that they are still subject to the Fair Chance Act. What this means is that the employer can ask applicants to fill out a pre-screening questionnaire, but can't ask on what basis the person qualifies for this program, or ask any questions that would force someone to reveal themselves as a person with a felony or a formerly incarcerated person until after the conditional offer. Alrighty, turning now to the fair chance process. Once an employer has extended a conditional offer of employment, it can run a background check on a candidate. This usually happens after the application and/or the interview, but this might differ depending on the individual employer's practices. If an employer is concerned about a conviction that comes up on someone's background check, the important thing to note here is that the employer can't just automatically take back the job offer. This is because under the Fair Chance Act, an employer can't just categorically refuse to hire all people with conviction histories, and similarly can't refuse to hire all people convicted of certain types of crimes. So saying something like no felons or no violent crimes. Instead, the Fair Chance Act requires the employer to conduct what's called an individualized assessment, and the 2023 regulations define that as a reasoned, evidence-based determination of whether the applicant's conviction history has a direct and adverse, so negative, relationship between the specific duties of the job such that the employer would be justified in denying the applicant the position. We're going to unpack that shortly. An individualized assessment must consider the following factors, which are known as the nature, time, nature test. First, the employer has to consider the nature and gravity of the criminal history. So, what was the harm caused by the criminal conduct? Second, the employer has to look at the amount of time that has passed since the conviction happened. And third, the employer has to look at the nature of the job. So what are the essential functions of the job and what is the job environment? The 2023 regulations provide examples of what types of factors an employer might consider when conducting the individualized assessment. So for the nature of the offense, an employer might look at, to the extent they have this information, the underlying conduct of the person or the context, whether the harm was to property or people, the degree and permanence of the harm, if they know whether disability contributed or perhaps some trauma, a trafficking situation or domestic violence, the person's age at the time. In terms of the time factor, an employer might look at how much time has passed since the incident, and if relevant, how much time has passed since the person was released from incarceration. In terms of the nature of the job, the employer might look at the specific duties of the job, whether the context in which the conviction occurred is likely to happen in the workplace, and whether the type or degree of harm is likely to occur again in this particular workplace. So let's look at a hypothetical. This is our friend Emmanuel. Emmanuel received a conditional offer for a job packing boxes at a warehouse. He has a 5-year-old misdemeanor conviction for statutory rape. He was 18 at the time of the offense and living in a group home after years of foster care. His mother passed when he was 14 years old. His father is in prison, and the complaining witness in his case was his 15-year-old girlfriend who also lived at the group home. Do we think there is a direct and adverse or negative relationship between his conviction history and the job packing boxes at a warehouse? Let's get into it. Looking at the nature time nature test to evaluate this, we have a lot of information here. So we know that this was a misdemeanor conviction, not a felony, for statutory rape. The harm was to a person. That person was underage and someone that he was in a dating relationship with. He also was quite young at the time. He was 18. And for whatever reason, if we have this information as the employer, we know that he has a history of trauma. His mother had passed away. His father was incarcerated, and he had been living away from his family. Turning now to the time factor, we know that 5 years have passed since the incident, which doesn't cut too much either way. It's not super recent, and it's also not super, super old. And then looking at the nature of the job, the duties of the job include packing boxes in a warehouse. It's really unlikely for the offense to happen in this context since it occurred in a really specific context, right? It was a dating relationship, it was a group home setting, and it's many years later. So let's say the employer in this situation wants to take back Emmanuel's conditional job offer due to his criminal history. There are certain things that the employer has to do. The law requires them to notify Emmanuel in writing of the preliminary or non-final decision to take back the job offer. That's called a pre-adverse action. And the notice has to include a list of the disqualifying convictions, a copy of his background check report, and any information about how he can respond to this decision. We'll get more into that in just a moment. The notice may, but is not required to include an explanation or justification for this preliminary decision. Note that the employer is required to give the applicant at least 5 days to respond. But if the applicant disputes the conviction history report or background check report, like maybe they think it's not accurate, then the applicant has 10 days. On the screen, I have an example of a sample notice that CRD has provided on our website. We have a bunch of sample notices that fulfill the requirements of the law, so I encourage you to check those out. The sample notice here includes something saying that a copy of the background check report is attached. It also has the list of convictions, and it includes information about the candidate's right to respond to the letter. So the notice from the employer has to explain that if an applicant wants to respond to the employer's decision to take back the job offer, they can provide one or both of the following. Information challenging the accuracy of the background check. So, for example, maybe the offense was listed as a felony when in reality it was a misdemeanor, maybe it's the wrong penal code section, etc. And or evidence of rehabilitation or mitigating circumstances. What does that mean? Rehabilitation and mitigation evidence can be highly individualized and may look really different depending on the person, but it might include the person's employment history before and after the crime, the facts or circumstances of the offense, any self-improvement efforts like job training, vocational training, community service, things like that, whether trauma, domestic violence, sexual assault, trafficking, or other similar factors may have contributed to the offense, the age of the person at the time of the conduct, whether a disability may have contributed to the offense, and whether a reasonable accommodation could mitigate or eliminate any risk of harm, or perhaps the disability has been mitigated or eliminated through treatment or something else. The likelihood that similar conduct will happen again, the fact that the person is seeking employment in and of itself is enough to be rehabilitation or mitigation evidence. and finally, the person's completion of or compliance with the terms of their supervision, like parole or probation. How do people submit rehabilitation or mitigation evidence? Usually it is in the form of documentary evidence. Documentary evidence includes, but is not limited to, certificates from educational, vocational training, counseling, community service, or a rehabilitation program, including in-custody programs. Letters of support may be from a current or former teacher, counselor, supervisor, coworker, parole or probation officer, etc. It may be police reports or protective orders or any kind of documentation showing someone's status as a survivor of domestic or dating violence, trafficking, sexual assault, stalking, or other types of offenses like that. Maybe it's documentation confirming the existence of a disability. But there are certain restrictions on documentary evidence as well, and this comes from the 2023 regulations. The Fair Chance Act prohibits employers from refusing to accept additional evidence that an applicant wants to submit, requiring an applicant to submit additional evidence or specific types of evidence, like a police report, maybe a court transcript, disqualifying an applicant for failing to provide any specific type of documents, requiring someone to disclose their status as a domestic violence or other survivor, though of course someone can volunteer that information if they wish, and requiring an applicant to submit medical records or disclose the existence of a disability or diagnosis. But again, someone can volunteer that information if they want. So let's turn back to our friend Emmanuel. Emmanuel responds to the pre-adverse action notice with letters of support from his last two bosses and a church leader, a certificate of completion from some programming, some community college transcripts, and a personal statement detailing the offense and his past, written with support from his case manager. Once the employer receives this evidence of rehabilitation and mitigation from the applicant, they have to reassess the person using the individualized assessment process that we discussed before, but considering the newly received information. So in addition to the factors that we've already talked about, the employer might consider the person's conduct during incarceration, if they were incarceration, including participation in any kind of rehabilitative programming, the applicant's work history since the conviction, their community service and engagement since the conviction, and any other rehabilitative efforts or mitigating factors that aren't listed here. If, after considering the information that the person submitted, so for example, let's say the employer considers Emmanuel's documents and all of the stuff that he provides, if that employer still wants to take back Emmanuel's job offer, they have to submit a final notice called an adverse action that includes information letting the person know that they're disqualified, any procedure that the employer has in place to challenge the decision, and the right to file a complaint with our department. So these are notice requirements under the law. Note that the notice may, but is not required to, include an explanation or a justification for its final decision. Once again, on the screen, I am showing another sample notice that is available on CRD's website. I encourage you to check out all of our sample notices on our website under Criminal History and Employment. We also have an interactive guide that helps people answer questions about their job search to find out if any potential violations of the law may have taken place in their situation. The guide provides some tailored reports listing potential red flags and explaining how to file a complaint with our department. Another thing I wanted to highlight is that CRD recently filed a lawsuit against the grocery store Ralph's for alleged violations of the Fair Chance Act. This lawsuit is actually one of the first of its kind since the Fair Chance Act has not been litigated in court very much. And what CRD is alleging is that people lost their jobs based on convictions that really had nothing to do with working at a grocery store. CRD is also alleging that Ralph's failed to do individualized assessments of candidates as they were required to by law. Finally, CRD is also alleging that Ralph's did not meet the notice requirements of the law and included illegal questions on its job application about criminal history. Last year, we also settled a $51,350 complaint against a healthcare company for alleged violations of the Fair Chance Act. As part of the settlement, the company is required to change its hiring policies to comply with the law, to train hiring managers on the law, and to report its compliance to CRD for 3 years. So just to give you a little bit of a sense of how we handle fair chance complaints. We also have received complaints against several big companies alleging that they unlawfully rejected otherwise qualified job applicants and failed to comply with the requirements of the law. So some big names that you might recognize include Amazon, IKEA, Kohl's, the Dodgers, the Citizen Hotel, and MPI Jet. So we had settlements in these cases as well. That is the end of this presentation. We encourage you to check out our other videos on our YouTube page and to reach out if you need any further support. Thank you.